Dear students, let us start the discussion on today's newspaper, that is 15th February 2017. The first article is The Long and Winding Road to Justice. It is about Prevention of Corruption Act. And most of the news today are related to the Tamil Nadu politics. We will see these articles from the governance dimension, especially from Prevention of Corruption Act dimension. Here we need to understand certain words. One important word over here is presumption of guilt. So this word is being used by this article in this page. Now if you see clearly, so there is a presumption of guilt is the word used over here. So we need to understand what is the meaning of this presumption of guilt is. And you know that the section 13 of the Prevention of Corruption Act defines what corruption mean. In this 13 subclause 1 subclause E, it clearly talks about disproportionate assets and disproportionate income. Let me say this way. So the assets possessed by an individual disproportionate to his known or her known sources of income can be considered as a corruption. Now, normally in the common law, presumption of innocence is the rule. It means that unless a person is proven to be guilty, he cannot be considered as guilty. So we have to start any proceedings on an individual, trial on an individual, assuming that he is innocent unless the law proves it otherwise, or else the due process proves it otherwise. But however, under 13 subclause 1 subclause E of Prevention of Corruption Act, what we have is this presumption of guilt. It means that if disproportionate assets are located, then we can assume that they are guilty, and the burden lies on the accused to prove that he did not acquire that money through illegal means or through corrupt means. So the presumption of guilt exists under Prevention of Corruption Act. The new amendment which has been proposed to the Prevention of Corruption Act, it wants to remove this presumption of guilt. So that is one way Yogendra Yadav says is going to weaken this particular law. And added to that, the delay in justice is the major reason for lack of deterrence against corruption in India. If you take J. Jayalalitha case, Selvi Jayalalitha case itself, it took 21 years to send the accused, convicted, to convict and send them to jail. And second, in India, the Supreme Court has clearly stated that the corruption is going to become a menace in our public life. And then, further to that, in Agnihotri versus State of Madhya Pradesh case, in disproportionate assets, if they are within the range of 10%, they can be concluded as within the range. And beyond that, it has to be considered as disproportionate assets and shall be convicted for. Now, the Michael C. Kunha, he has convicted Jayalalitha, Ms. Sesikala and Ilavarsi and Sudhakaran on stating that they are more than 80% of known sources of income. And later, Karnataka High Court has reversed the judgment, and it has relied on income tax returns filed by Jayalalitha. So in this context, what we can say is there is no clear understanding of the case which the trial judge did, and then it went to the Supreme Court. The Karnataka state government has thought twice before appealing the matter before the Supreme Court. Under the pressure of the people, it has been appealed. Finally, what is the judgment we got today? We are seeing. And Supreme Court also faulted the mistakes of the High Court judge, Mr. Kumaraswamy, and also praised Mr. Michael C. Kunha for his sensitive and detailed work. So why I am telling all this story? It is to explain that the judicial process is also becoming unfair in India. So or else, I'm not accusing anyone of corruption in the judicial process over here, but one major problem in India is judicial corruption too. And then, let's get into the next article. It is about Donald Trump. So in this article, we are going to talk about The early setback for Mr. Trump. So, this article about National Security Advisor Mr. Flynn, he was asked to step down. Now, see, a president's ability to run the government depends upon the people who is choosing to his cabinet. Or I can say it as a leader can prove himself by selecting the right people to the right job. So Mr. Trump appears to be failed on this front. The National Security Advisor, Mr. Flynn, he spoke to the Russian ambassador in the United States about the sanctions imposed by the President Obama when Obama was still in office. According to Logan Act, it has been clearly stated that the Logan Act, it stated that no civilian can conduct the government diplomatic affairs. So the president-elected Trump did not take the office. Even then, Mr. Flynn has taken an initiative for this. So in this context, he was asked to step down. And the second thing is, not just Mr. Flynn and many other people, for example, attorney appointed by Mr. Trump and also the defense secretary, everyone have their set of controversies. So this we need to be understood. And here we have to say this way. The parliamentary system has greater checks and balances compared to the presidential system. The reason being is in parliamentary system, accountability is on a day-to-day basis, but in presidential system, there is a much leeway for the executive. But however, in the system of checks and balances, every appointment made by the executive has to be approved by the legislature in the United States. Now, one way that is hindering the administration. Now, I can say it this way. America failed to pass its budget twice because of the opposition in the House. But that cooperative situation exists in India in our parliamentary system. So in presidential system where checks and balances are there, the governance has got hijacked by only a minority of people. That is one other criticism over there. So these are the things we need to talk about. Now coming to the perspective page. So the importance of goods and services. So in this article, the general belief in India is the voting behavior of the voters is based on their identities. Either they are caste or religious identities. But in India, caste may be an important tool or important instrument with regard to a social life. But however, today, the political behavior of the voters is changing. The economic delivery of goods, public goods, by the government in power is more determining the voting behavior rather than purely the caste or communal identity. That is what this article stresses on. It means the voting behavior is becoming more rational from the perspective of the voters. Now, coming to the ecological balance sheet. Now, there is no much in this article. So, any program or plan, one point which we write is insufficient finances. So, the environmental protection in India is no way different from this. We have lofty objectives in environmental protection, but the budgetary allocations are very minimal. So the government, it has clearly stated in its policy strategy document that it will provide for a stable environment for the private sector to create wealth. The stable environment, it means peaceful and stable law and order situation. But environment is also seen as an obstructionist for the economic growth to happen, which is the primary goal of the government. So the budgetary allocations are decreasing, and added to that, the allocations which are being made are underutilized for. So that is what is the greater concern expressed by this particular article. So here you can clearly see that what is the fiscal policy strategy statement says. It clearly states that economic growth is the objective. How this economic growth has to come from? From a safe and stable environment created for the private sector to operate and create wealth. Now, let's get into the next article. The news page, exit poll, online editor of Daily Health. You know that in India, exit polls are being banned. But an enthusiastic editor has published them on online platform, which has made the election commission to issue a notice for the same. So here we need to understand that the Representation of People's Act 126A subclause 1, It clearly prohibits the conduct and publicizing of the exit polls and while the election process is on. In this, it can be led to a punishment up to 2 years with penalty. So in this case, again, it is also a cognizable offense. It means what is the cognizable offense? The police have the authority to make an arrest without a warrant or a permission from the court. That is what we call it as a cognizable offense. So section 126A subclause 1, according to this, publishing of the exit polls when the election process is on is a cognizable offense. Now the next is Triple Talaq Uniform Civil Code. Now you know that Uniform Civil Code is a much wider topic that is synchronizing all the personal laws towards uniform or universal law directing the civil life. And Triple Talaq is dealing with only an aspect of the religion, especially that is Muslims. In this, is Triple Talaq polygamy halala? Are they are against to the provisions or the rights guaranteed in our constitution is not? Is the matter of question before the judiciary. That is what is been spoken about over here. Now, here there is a word used that is called as composite floor test. So we need to understand this word composite floor test over here. It has been clearly stated that many of the legal advisories have recommended composite floor test for Governor Vidyasagar Rao in the case of Tamil Nadu. So, composite floor test is nowhere stated in our constitution. It is a judicial innovation. So, in Uttar Pradesh, when Kalyan Singh and Jagadambika Pal, they were contesting for the chief minister's post, then the Supreme Court ordered for a composite floor test where the ballot papers are being issued for the MLAs. Based on the selection of the MLAs, the chief minister was reinstated. So it is a judicial innovation. Now here we need to differentiate that from a practice in Germany. So this is what is called as a constructive motion of no confidence. Here also a no confidence motion is taken simultaneously along with the confidence motion. It means you are stating or voting on no confidence motion. Alternatively, you also have to vote on the confidence motion for the alternative. So it helps not to trivialize the no confidence motion. So India is also talking about this constructive no confidence motion to bring in the stability for the functioning of the government. So the composite floor test and constructive motion of no confidence, they are not one and the same. So that I am trying to differentiate over here. Now I have prepared the notes. So in this we have discussed what is presumption of guilt, and the second is we have also discussed the composite floor test, and then the Prevention of Corruption Act and its provisions. And Michael Flynn, here we need to talk about leadership issue. A leadership is determined by the nature of his followers, not by his own style. So the leadership is of different types, but the followers determine the nature of the leader or determine the character of the leader. Probably Mr. Trump has failed on this front. That's what I wanted to conclude. So these are the news for today, and thank you very much and all the best.